Welcome to the deep dive. This is where we take some really interesting material, like the great stuff you've provided, and, really get into it, figure out what's vital, how it all connects, and what you definitely need to grasp.
Uh-huh. We try to find those aha moments, maybe even a surprise or two.
Exactly. And today, we are diving deep into the world of trademarks. It's a fundamental area.
It really is. And the material we're working from today, it's fantastic stuff made available by the University of London. We absolutely want to thank them for providing these resources for educational use.
Yes, a big thank you to the University of London. And just to be clear, this whole deep dive is purely for educational purposes. We're here to help you get to grips with this topic.
That's the goal. Think of this as helping you navigate the complexities, especially if you're studying this for, for exams.
Absolutely. And speaking of support, this deep dive is brought to you by Sinorbit Academy, Sri Lanka. And for all of you hitting the books right now, seriously, the very best of luck with your studies and your exams.
Yeah, good luck, everyone. So our mission today, we want to unpack this material thoroughly. We'll look at the sometimes surprising history of trademarks.
Okay.
Really pin down what a trademark is, legally speaking, and how it sits alongside other IP rights like patents or copyright.
Right, the comparisons are important.
Definitely. Then we'll look at the functions they perform, which is crucial, and the huge influence of EU law on the UK system, even now, post-Brexit.
That EU influence angle is fascinating. Okay, let's dive in then. History first. Section 10.1 in the material.
Right.
Where does this journey begin?
Well, you might be surprised. The idea of marking things, it goes back thousands of years. It's not just some modern legal thing.
Thousands. Really, like ancient history, ancient.
Exactly that. Some of the very first examples are about showing ownership, branding cattle,
Yeah.
literally burning a mark on them.
Yeah, I know the practice.
That's an ancient example.
Yeah.
And here's a great little connection that's actually where our modern term brand name comes
Yeah.
from that literal branding,
No way. Branding cattle to brand names. I love that. That makes so much sense.
doesn't it? And it wasn't just animals. Archaeologists, they found loads of evidence. Marks on pottery in ancient China indicating who made it. Similar finds from Greek and Roman times, too. Basic marks, but they did the job identifying goods or their source.
Okay, so ancient ownership, ancient source identification. Where do we jump to next?
We fast forward quite a bit to medieval Europe. And here, the
Okay.
material points out, marks were used in two really practical, distinct ways.
Two main uses in medieval times. Okay, what were they?
First, you had proprietary marks. Still about ownership, really. Often just initials or a personal sign put on goods.
Why was that so necessary back then? Was trade that risky?
Incredibly risky. Yeah. Think about it. Pirates, shipwrecks, transport was hazardous. If your goods got lost or stolen and then maybe recovered later, having your mark on them was solid proof it was yours.
Oh, right. Evidence.
Exactly. And this wasn't just some local custom. It was recognized in law in lots of European trading cities. Even in England, you see it enforced by the courts much later. There's that case, Hamilton v. Davis from 1771, Lord Mansfield himself upholding the practice. So proof of ownership was legally recognized.
Okay, proprietary marks for ownership, especially with risky transport. Got it. What was the second medieval use?
The second type was production marks. And these served a completely different purpose, a really important one. Consumer protection.
Consumer protection back then. How did that work?
Through the craft guilds,
Hmm.
Swordsmiths, goldsmiths, weavers. These were highly regulated trades.
Like early professional bodies.
Sort of, yeah. And they had strict quality standards. To enforce these, and for accountability, rules often require the goods be marked with the sign of the individual maker.
Ah, so if your sword snapped, you knew who to blame.
Precisely. Faulty workmanship. The mark traced it right back to the craftsman. And there were often serious penalties, even criminal ones. But here's a key difference from today, the material notes. Back then, the guild often held the collective reputation, the goodwill for quality. Not so much the individual trader. People often bought directly from the maker. Totally different from mass production and retail sales today, where the brand represents the company's goodwill.
That is a crucial distinction. Guild reputation versus individual or company brand goodwill.
Okay, so ancient ownership, medieval ownership, and quality control via guilds. What pushed things towards modern trademark law? What was the catalyst?
Oh, unquestionably, the Industrial Revolution. That wasn't just about machines. It changed everything about society and how trade worked.
Right. How did that impact marks specifically?
Well, think about the shift. From small workshops selling directly to huge factories churning out goods.
Mass production.
Exactly. Goods transported miles away, sold through retailers. That direct link between the person who made it and the person who bought it. Gone. So the mark suddenly had to do a lot more work. It had to tell the consumer, this is the product you liked last time, even if they bought it from a different shop and had no idea who actually made it.
Precisely. The mark became the main identifier, the bridge across that distance. The rise of the mass consumer society created the whole context for modern trademark law. Consumers needed a way to pick out products they trusted again and again.
Okay, need established by industrialization. So how did the UK legal system catch up?
It was, well, a bit piecemeal at first. Before specific laws, it emerged through cases, mainly 18th and 19th century. And there's that common myth about the first case.
Let me guess. Southern v. Howe, 1618.
That's the one everyone mentions.
Yeah.
But as the material rightly points out, it wasn't really about trademarks. It was an agency law case. The mark reference was just, irrelevant.
Okay, so not the first. When do real trademark cases appear?
Proper cases dealing with marks identifying goods start showing up later, 18th and especially 19th century. And they appeared in two different court systems initially.
Common law courts and the Court of Chancery.
That's right. Early 19th century, common law courts heard cases like Sykes v. Sykes in 1824, Blofeld v. Payne, 1833, Crochet v. Thompson, 1842. The legal basis. It was derived from the tort of deceit.
Deceit. So basically lying or tricking someone.
Essentially, yes. And crucially, to win in common law, you had to prove the defendant had fraudulent intent. You had to show they were deliberately trying to pass off their goods as yours using your mark.
Wow, proving intent sounds tough.
It could be a high bar. Interestingly, you didn't necessarily have to prove customers were actually fooled, or even that the defendant's stuff was worse quality. The focus was purely on the defendant's dishonest intention.
Okay. Meanwhile, what was happening over in Chancery, they dealt with different remedies, right? Injunctions.
Exactly. Chancery could grant injunctions orders to stop someone doing something. But initially, they were reluctant to protect trademarks. Cases like Blanchard v. Hill in 1742 and Crutwell v. Lye in 1810 show them refusing injunctions.
Why the hesitation in Chancery?
The big worry, and this keeps coming up, was about creating an unfair monopoly. Judges were concerned that granting exclusive rights to a mark could stifle competition. We'll see this monopoly concern pop up again and again.
That's fascinating. That concern was there right from the start of the legal system grappling with this. Did Chancery change its mind?
Yes, it did. They started by protecting something called the get-up of a business.
Get up. What's that? Like the overall look?
Pretty much. The visual presentation, packaging, colors, lettering, the whole style. There's a famous case, Knott v. Morgan from 1836. The defendant was stopped from copying the specific color scheme and writing style the claimant used on their London omnibuses.
So not just the name, but the whole visual identity of the buses.
Right. And then, just 2 years later, something really pivotal happened in Chancery. A landmark case.
This must be the big one.
It is. Millington v. Fox in 1838. The Court of Chancery declared, quite fundamentally, that trademarks were a form of property.
Property, like owning land.
Yes, but intangible property. And this was huge. Why? Because if a trademark is property, then someone using it without permission isn't just being deceitful, they're trespassing on your property.
So liability changes completely.
Completely. It shifts to strict liability. You no longer needed to prove the defendant intended to deceive, like in common law. You didn't even necessarily need to show the public was confused or that you'd suffered harm. Using the mark without permission was, in itself, a violation of the property right. Let's repeat that. Millington v. Fox established trademarks as property, shifting liability to strict liability.
That is a massive change, from proving bad intent to just proving unauthorized use of your property right.
Absolutely fundamental. But confusingly, the courts weren't immediately consistent after Millington v. Fox. Some cases still followed the old common law path, needing proof of likely deception. Think Perry v. Trufitt, 1842, Croft v. Day, 1843. Others followed the new Chancery property approach, where deception was irrelevant. Hall v. Barrows, 1863, Edelston v. Edelston, 1863. So it's still a bit of a mess legally.
Okay, different courts, different rules. Sounds chaotic. How did they sort it out?
Legislation was needed, and reform came, starting around 1875. First, the Judicature Acts of 1873-75 reorganized the whole court system, merging common law and Chancery courts. IP cases like trademarks went to the Chancery Division, and generally, Chancery's equity rules prevailed over common law, where they conflicted.
Right, streamlining the courts. But you mentioned passing off earlier. The modern descendant of these cases still needs deception.
That's a really interesting wrinkle, isn't it? Despite the Judicature Acts aiming for consistency, the tort of passing off, which grew out of these old actions, did keep that common law core requirement of proving customer deception or confusion, although how deception is interpreted has broadened over time, so that common law element persisted there.
Interesting divergence. So the courts were reformed. What about specific trademark law?
Well, 1875 was the watershed year. That's when the very first dedicated trademark statute was passed. The Trademarks Registration Act, 1875. Its name tells you the key innovation. It introduced the first official system for registering trademarks in the UK. Let's repeat that. The Trademarks Registration Act, 1875, was the first UK act to introduce formal registration.
Another huge step, moving from just relying on proving use in court to having a government register.
Absolutely. This laid the foundation. It was followed by more acts in 1905, and then the really significant 1938 Act, which was the main law for quite a long time.
The 1938 Acts, that sounds important.
It was a major consolidation. But by the 1970s, it was seen as getting outdated. The Mathis Committee reviewed it in 1975 and recommended a big overhaul.
Did that happen?
Not really. Only one major change came out of that specific review. Protection was finally extended to service marks for services like banking or airlines, not just goods. That was via the Trademarks Amendment Act 1984. So let's repeat. Service marks were first protected in UK law by the 1984 Act.
Took a while for services to get explicit protection then. So what finally triggered the big overhaul that led to the current law, the 1994 Act?
That was the 1990 White Paper on Reform of Trademarks Law. It clearly laid out why a new act was urgently needed. Repeat that. The 1990 White Paper outlined the key reasons for needing the 1994 Act.
Okay, what were those compelling reasons?
Several big lists. First, the old law, mainly the 1938 Act, was just seen as too old, too clunky for modern business. Second, and this was massive, the UK had to implement the first EU Trademarks Directive. Repeat. Implementing the EU directive was a key driver. Harmonization across Europe was the goal.
EU harmonization, a familiar theme in UK law reform around that time.
Very much so. Third, the UK needed its system to work with the new EU-wide trademark office, OHIM as it was then called, now UIPO, set up by the Community Trademark Regulation. Fourth, international treaty obligations ratifying the latest version of the Paris Convention. And fifth, a desire to join the Madrid Protocol, an international registration system, though the material notes that's not core syllabus.
Got it. Outdated law, EU requirements, international cooperation, a perfect storm for reform.
Precisely. All these factors led directly to the Trademarks Act 1994, our current main legislation. Repeat, the Trademarks Act 1994 was enacted specifically to address these issues, especially EU harmonization.
Okay, what a journey. From ancient branding, medieval guilds, the Industrial Revolution shakeup, messy court cases eventually leading to the property idea, then the 1875 Act bringing registration, and finally the 1994 Act driven by modern needs and the EU.
That sums it up nicely. See those two streams, the factual history of trade changing and the legal history of the courts and parliament trying to keep up.
It really connects law to the real world, which leads us perfectly into Section 10.2, the nature of trademarks. So legally speaking, what is a trademark today under the 1994 Act?
Fundamentally, a registered trademark is defined as personal property.
There's that connection back to Millington v. Fox.
Exactly. That concept became central. Like other statutory IP rights patents, registered designs, it's an exclusive right. The owner can stop others using the mark, or something confusingly similar, for specific goods or services.
And the 1994 Act explicitly says personal property.
Yes. Section 2 of the Trademarks Act, 1994, it's crystal clear. A registered trademark is personal property, an intangible right specifically. Repeat, under S.2 of the 1994 Act, registered trademarks are personal property.
So if it's property, can you treat it like other property? Sell it? License it?
Mostly, yes. It has the usual attributes. You can sell it, that's assignment. You can license others to use it, maybe for royalties. You can even use it as security for a loan, like a mortgage. Companies value brands hugely on their balance sheets. The COCH UoL mark, for example, estimated value in the tens of billions.
Incredible value. But the material flag's a key difference from, say, owning a house. Something unique about trademark property.
Yes, this is really important and quite unusual in property law. A registered trademark can be removed from the register. The property right can essentially just vanish.
How? You don't usually lose property just like that.
No, exactly. That's the big difference. There are two main ways. First, like patents or designs, it can be declared invalid if it shouldn't have been registered in the first place. maybe wasn't distinctive enough. But the really unique way is revocation, which is often linked to the owner's actions or inaction. Repeat. Trademarks are unique because the right can be lost through revocation based on the owner's conduct.
Revocation. What triggers that? What does the owner have to do or not do?
The details come later, but the key grounds introduced here are, first, non-use. If you don't genuinely use your mark for 5 years for the registered goods services, it can be revoked.
Use it or lose it, basically.
Pretty much. Second, generic use. If the mark becomes the common name for the product itself, because of how the owner used it or let others use it, think Hoover for vacuum cleaners, potentially. If it becomes generic, it stops distinguishing your goods, so it loses its core function.
So letting it become too successful in the wrong way.
Kind of. And third, deceptive use. If the owner uses the mark in a way that misleads the public about, say, the product's quality or origin, so the property right comes with responsibilities.
That's a major difference. Property, but conditional property linked to its market function. Okay, how do trademarks compare to other big IP rights like patents or designs? There can be overlaps.
Oh, definitely overlaps.
Yeah.
A 3D shape, for instance, could be a trademark, think the Coke bottle shape, though there are exclusions in Section 3.2 of the Act for purely functional shapes, things like that.
Right, you can't monopolize function through a shape mark.
Exactly. And a logo, a pictorial mark, that can easily have both copyright as an artistic work and trademark protection. The R. Griggs Group v. Evans case confirms this. Repeat. Pictorial marks can have both copyright and trademark protection. Even sounds distinctive jingles can be trademarks.
Okay.
The CJEU confirmed this in Shieldmark v. Kist. Repeat. Tunes or sounds can function and be registered as trademarks.
So sounds, shapes, pictures, but
Yeah.
not everything.
Right. An invented word like XX on N. Brilliant trademark. Very distinctive. But is it a copyright literary work? Probably not, according to the Exxon Corporation v. Exxon insurance case. Repeat. An invented word might be a great trademark, but not get copyright protection.
Interesting distinctions.
Yes.
What are the really fundamental differences then between trademarks and patents or designs?
Okay, several big ones. First, creativity. Patents protect inventions' new inventive steps. Copyright protects original creative expression. Designs protect aesthetic appearance. Trademarks. They require no ingenuity, no creativity, no aesthetic merit in that sense.
Not at all.
Nope. A common word, a color, a simple shape, a sound. Anything that can distinguish your goods or services from others can be a trademark, as long as it actually does distinguish them or acquires distinctiveness through use. Repeat. Trademarks don't need inventiveness or aesthetic creativity. Their job is distinction, not creation.
That's a core difference. What else?
Scope of the right. Patents and registered designs give you largely absolute rights. If someone makes your patented invention, that's infringement. Full stop. Trademarks. Generally not absolute, with one narrow exception.
What's the exception?
Using an identical mark on identical goods services, that's the strongest case, potentially infringement without more. But for almost everything else, similar marks, similar goods, even identical marks on dissimilar goods for famous marks, you usually need to prove something extra.
Like what?
Usually either a likelihood of confusion among consumers, or, for marks with a reputation, that the use causes harm to the mark's reputation or takes unfair advantage of it. Repeat. Unlike patents, TM infringement usually requires proof of likely confusion or harm to reputation.
So it's not just they use my mark, it's they use my mark and it's causing confusion or damage.
Generally, yes. And the use has to be trademark use in the course of trade, in relation to goods services, and it must affect the owner's interests, usually by interfering with the mark's functions. The Arsenal v. Reed case highlighted this need to affect the owner's interests. Repeat. Infringing use must affect the TM owner's interests.
Less absolute often needs confusion or harm. What about the basic reason why we grant these rights? The justification, is that different too?
Hugely different and really important for understanding trademarks. Patents, copyright designs, often justified by rewarding creativity, encouraging progress, maybe natural rights of the creator. Trademarks, justified primarily on economic grounds. Repeat. Trademark protection is economically justified by reducing consumer search costs and promoting efficient competition.
Reducing search costs, how does protecting Nike do that?
Think about shopping. You see the Nike swoosh. You instantly know something about the likely style, quality source based on past experience or reputation. You don't need to inspect every shoe on the shelf. The mark is a shortcut. It saves you, the consumer, time and effort finding what you want.
Okay, makes sense. Like a quality signal.
Exactly. And by helping consumers choose easily, And rewarding companies for building trust through consistent quality, it promotes competition. Companies invest in their brands, knowing customers can find them again. It makes the market work better.
So less about rewarding invention, more about market efficiency and information.
That's the core idea.
Mm.
Now, despite not needing creativity, trademarks have one potential superpower over other IP duration. Patents, 20 years. Designs, max 25. Copyright, life plus 70. Trademarks, potentially forever.
Forever. How?
Simple. Pay the renewal fees every 10 years. If you keep paying and keep using the mark properly, the registration can last indefinitely. Repeat. Trademarks can potentially be the longest-lasting IP right. Think about the Bass Red Triangle, TM-01 from 1875, still registered today.
Incredible. So valuable, potentially eternal property justified by economics. But you mentioned a love-hate relationship with competition.
Ah yes, the tension. While they help consumers choose between existing brands, very strong trademarks can create massive barriers to entry for new players.
How so?
Imagine trying to launch a new cola against Coke and Pepsi, or new trainers against Nike and Adidas. The amount you'd have to spend on advertising just to get noticed, to persuade people to try yours instead of the brand they know and trust. It's enormous. The established brand's reputation, protected by the trademark, makes it really hard for newcomers.
So good for competition between the big guys, maybe, but tough for anyone trying to break in.
That's the argument, and it links back to that old judicial worry about monopolies. The material notes that judges, even in relatively recent cases like Rocoki, UoL trademarks, or British Sugar v. James Robertson, have sometimes expressed concern about trademarks creating monopolies. Repeat. Some UK judges have worried about trademarks creating monopolies.
But are they really monopolies in the economic sense?
Well, probably not. Owning the Kawakaki UoL mark doesn't stop anyone else making cola drinks. They just can't call it Koica UoL or use a confusing logo. The right is over the sign for specific goods, not the product type itself. It doesn't stop historians writing about Coke or botanists discussing the cola plant.
So if not a true economic monopoly, why the judicial concern?
That's the critical question the material leaves us with. Is it the potential perpetuity, the low creativity bar compared to patents, or just the sheer market power a huge brand commands, which feels like a monopoly over consumer choice, even if it isn't over the product? It's a fundamental tension.
That really paints a complex picture. Valuable, long-lasting, conditional property, economically justified, but always rubbing up against competition concerns.
And that leads us perfectly into Section 10.3, the functions of trademarks. This, the material stresses, is absolutely crucial, highly examinable stuff.
Why are the functions so central?
Because understanding how a sign actually works as a trademark in the marketplace, what it does underpins almost everything else. Is it registrable? Is someone infringing? Can it be revoked? It all comes back to function. Repeat. Understanding trademark functions is essential for all subsequent topics.
Okay, vital. So what are these functions? The material starts with an older view.
Yes. Frank Schechter, back in 1927, talked about the mark's job being to create and retain custom by protecting its selling power against free riding. Very insightful. But for a long time in the UK, certainly before the 1994 Act and EU influence, judges tended to see only one main function.
Which was?
Simply indicating commercial origin, telling the consumer where the goods came from. Now, an important point made clear in old cases like Powell v. Birmingham Vinegar Brewery and McDowell's application is that the consumer doesn't need to know the actual company name, just that goods with that mark come from the same consistent source. An anonymous source is fine as long as it's consistent. Repeat. The origin function means indicating a consistent, even if anonymous source.
So you trust the mark itself, not necessarily knowing the company behind it.
Exactly. But this traditional origin function, it got a major update, largely thanks to EU law and the 1994 Act. And the absolutely critical case here, the one you really need to know, is Arsenal Football Club v. Matthew Reed. Repeat. Arsenal v. Reed is a vital case for understanding the modern origin function.
Ah, the football case. What happened there? Why was it so important for the origin function?
All right, so Arsenal sued Mr. Reed, who sold unofficial Arsenal merchandise scarves, shirts with the club crest outside the ground. In the UK High Court, the judge, Laddie J., took a very narrow view of origin. He said, basically, the fans knew this wasn't official club stuff. They bought it as a badge of allegiance, not thinking it came from the club. So he argued the mark wasn't functioning to indicate origin in that context, therefore no infringement.
Wow, that seems restrictive for brand owners.
Hugely. It would have gutted trademark protection, especially for famous brands. The case went to the CJEU, the European Court of Justice, and they took a much broader view of the mark's essential function.
What did the CJEU say was the essential function?
They said it's to guarantee the identity of origin, enabling consumers to distinguish. But crucially, they added, the mark guarantees that all goods bearing it are under the control of a single undertaking, which is responsible for their quality. Repeat, the CJEU, in Arsenal, expanded the essential function to guarantee origin under the control of a single undertaking responsible for quality.
Ah, linking origin directly to the owner's control over quality. That's a big addition.
Massive. And they also talked about protecting the owner's specific interests, like their investment in building the brand's reputation. When the case came back to the UK Court of Appeal, they followed the CJEU's broader approach.
So Arsenal, via the CJEU, broadened the origin function considerably under the 1994 Act.
Yes. Now, origin isn't just where from. It includes the consumer's interest in consistent quality linked to the owner's control and the owner's interest in protecting their investment against misuse.
And that link to origin helps explain why passing off the common law action still usually requires confusion about source, right? Like in
Yeah.
Herod's v. Herodian school.
Exactly. Passing off often hinges on proving origin confusion, suggesting its scope might be narrower than the registered mark system post-Arsenal. That's relevant later for things like character merchandising.
Okay, function 1, origin, expanded by Arsenal. What's number 2?
Function 2, the product differentiation function. This one's actually right there in the definition of a trademark in Section 1.1 of the 1994 Act, which itself comes from Article 2 of the EU Directive.
Right.
Repeat, Section 1 of the 1994 Act and Article 2 of the Directive describe the product differentiation function.
How does the Act put it?
It says a trademark is a sign capable of distinguishing the goods or services of one undertaking from those of others. Simple as that. It helps consumers choose between competing products.
Telling my Coke from my Pepsi, my Nike from my Adidas.
Precisely. It enables informed choice. Now, is this just another way of saying origin, or does it go a bit further, maybe by linking choice to expected quality, tying back to Arsenal again? The CJEU does use facilitating choice as a test when deciding if certain signs can be registered at all.
Okay, origin, differentiation, function 3.
The guarantee function. Now, be careful here. This isn't a guarantee, like in sales law, this product won't break. It's about guaranteeing consistent quality. Repeat. The guarantee function assures consumers of consistent quality from that source.
So if I buy this brand again, it'll be the same standard as last time.
Exactly that. It's a promise of consistency. And interestingly, this function has been protected under passing off law, especially in its extended form.
Extended passing off.
Yeah, like in the old case Spalding v. Gamage, 1915. The problem wasn't just fakes, but selling dodgy, inferior versions of the claimant's A1 quality goods. That damaged the A1 mark's reputation as a guarantee of quality.
And the supermarket lookalikes. The Penguin Biscuit case.
United Biscuits v. Asda, 1997, yes. The court found Asda copying the Penguin get-up misled shoppers into expecting the same quality, harming Penguin's guarantee function. Repeat. Spalding and United Biscuits v. Asda show the guarantee function protected in passing off.
And this guarantee idea was also crucial in those EU parallel import cases.
Absolutely. Hague 2, 1990, is the classic. Two firms using the same Cafe H mark, but with different quality coffee due to history. The CJEU said the original owner could stop imports of the other version because it broke the mark's guarantee of consistent quality, misleading consumers. Repeat. Hague 2 highlighted the guarantee function in parallel imports, even with a common origin. Other cases like Boehringer Ingelheim, pharmaceuticals, and Gillette reinforced this. Consumers rely on the mark for assurance about the product's integrity and quality. And as the CJEU said in Arsenal, guaranteeing quality is part of the origin function that helps consumers choose.
So guarantee links back to origin and differentiation. And it raises that question again, does this give trademarks a consumer protection role? A bit like those old medieval marks.
It certainly points that way. The law is protecting consumer expectations based on the brand.
Okay, origin, differentiation, guarantee. What's function 4?
Back to Schechter, the advertising function. This is about protecting the mark's selling power, its ability to attract customers, its goodwill against others, free riding on it. Remember, Arsenal mentioned protecting the owner's investment. That fits here too.
How does UK law protect this advertising power specifically?
Primarily through sections 5.3 and 10.3 of the Trademarks Act 1994. These came from the EU directive and deal specifically with marks that have a reputation. Repeat, sections 5.3 and 10.3 of the 1994 Act protect marks with a reputation, reflecting the advertising function.
What do those sections let the owner do?
They allow the owner of a mark with a reputation to object to the registration or use of an identical or similar mark, even for dissimilar goods or services, if that use takes unfair advantage of or is detrimental to the distinctive character or repute of their famous mark.
And this is the dilution idea.
Exactly. These sections are seen as introducing the concept of dilution into UK law. Repeat, sections 5.3 and 10.3 introduce dilution protection. Dilution means harm to a famous mark even without consumer confusion.
What kinds of harm does dilution cover?
The material outlines three main types. First, dilution proper or blurring, watering down. Using the mark on loads of different things weakens its unique association. Schechter's example, Rolls-Royce on lipstick, weakens the car brand image.
Loses its punch.
Right. Second, tarnishing. Using the mark in a context that's unsavory or degrades its image. The famous case is Claire & Clarin. Repeat, Claire & Clarin is a key tarnishing example. The gin maker stopped registration of Clarin for toilet cleaner the association was damaging.
Toilet cleaner and gin. Yeah, I can see the problem.
Definitely tarnishing. Third, free riding. Simply using a similar mark to leech off the famous mark's reputation and attract customers without doing the hard work yourself.
And the crucial point for these sections 5.3 and 10.3 is that you don't need to prove confusion.
Absolutely critical and initially misunderstood in the UK. Early cases like Baywatch wrongly insisted on confusion. Repeat, early UK courts mistakenly required confusion for SS.53, but the CJEU corrected this firmly in cases like Sable v. Puma and L'Oreal v. Ballure. Repeat, the CJEU confirmed confusion is not needed under SS.53 and 10.3.
Why no confusion needed?
Because, the CJEU said, these sections protect something different. They protect the mark itself as an asset, its advertising power, its reputation against dilution, tarnishing, and free riding. That harm can happen even if no one's confused about where the goods came from. The CJEU even extended this protection to use on similar goods, not just dissimilar ones, in cases like Davidoff and Adidas.
So the advertising function, protected here, guards the brand's value and magnetism against specific harms beyond just source confusion.
Precisely. The law recognizes the mark as a valuable communication tool and investment and protects that investment.
And there was mention of maybe a fifth function?
Yes, potentially. In the Interflora v. Marks and Spencer case, 2011, the CJEU talked about an investment function. Repeat, Interflora v. M&S introduced the potential concept of an investment function. This was described as the mark's role in acquiring or preserving a reputation that attracts and keeps customers.
How's that different from the advertising function? Sounds very close.
It does overlap, but the CJEU seemed to suggest it was distinct, maybe more focused on protecting the owner's ability to use their own mark, to build and maintain reputation and loyalty, rather than just stopping others free riding. It's about interference with the owner's own brand-building efforts.
A subtle distinction, maybe? And the Lush v. Amazon case was an example where these functions mattered in practice.
Yes. It shows how courts grapple with these functions when deciding infringement cases. Understanding all these functions, origin plus quality investment, differentiation, guarantee, advertising, plus dilution, tarnishing, free riding, and potentially investment is fundamental. Repeat. Understanding the trademark functions is vital for applying the law.
Wow. Origin, differentiation, guarantee, advertising, investment. It's way more complex than just badge of origin.
It reflects how brands work in the modern economy. Which brings us nicely to the last section, 10.4, the continuing significance of EU trademarks law. Brexit happened, but EU law's shadow is long here, isn't it?
Very long. The EU had that twin-track approach to trademarks for the single market.
What were the two tracks?
First, standardized national laws via directives. The key one was the first trademarks directive from 1988. Repeat. The first trademarks directive aimed to harmonize national TM laws. Second, create a single EU-wide registration system via a community trademark regulation 1994. Repeat, the community trademark regulation created an EU-wide TM right.
And the wording in both the directive for national laws and regulation for the EU mark was very similar on key things like registration and infringement.
Yes, virtually identical on many crucial parts. That's why CJEU cases interpreting one are often relevant to the other.
And there was newer EU legislation just before Brexit, too.
Right.
The EUTM regulation replaced the old one, governing the European Union trademark, EUTM. That's handled by the UIPO, European Union Intellectual Property Office in Spain, formerly OHIM. Repeat. UIPO handles EUTM applications. And there was a new directive in 2015, which the UK implemented via the Trademark Regulations 2018. Repeat. The UK Trademark Regulations 2018 implemented the 2015 EU directive.
So the UK updated its law to match the latest EU standards shortly before leaving.
Exactly. And this is why the EU influence is still so strong. Post-Brexit, EU TMs don't cover the UK. But under the withdrawal agreement, the Trademark Regulations 2018, the 2015 directive they implemented, and critically all pre-Brexit judgments of the CJEU interpreting that directive remain binding on UK courts. Repeat. Pre-Brexit CJEU judgments interpreting the directive are still binding in the UK where relevant.
Binding unless the UK Supreme Court decides to depart from them, which is a big step.
A very big step. So for practical purposes, that huge body of CJEU case law on how to interpret the directive's provisions. Still absolutely key to understanding the 1994 Act and the 2018 regulations in the UK today. And the CJEU had its own way of interpreting.
That teleological approach you mentioned?
Yes, exactly. Repeat. The CJEU uses a teleological approach, interpreting law based on its objectives. They look at the purpose, the goals of the legislation, often using the recitals or preamble, not just the literal words. Understanding that helps make sense of their rulings.
So the directive shaped UK law, the CJEU rulings explain the directive, and those rulings are still binding. What about the EU-wide mark, the EUTM system itself? Does that still matter for UK law?
Indirectly, yes. Decisions from EU-UIPO appealed to the EU's General Court, and then the CJEU generated a massive amount of case law on the EUTM regulation. Because the regulation's wording mirrored the directive, this case law was also highly influential on how UK courts and the UK IPO interpreted the corresponding bits of the 1994 Act.
So even though EUTMs don't apply here now, the reasoning in pre-Brexit EUTM cases from the CJEU can still guide UK courts on similar points in UK law.
Exactly. If the legal point is based on wording derived from the directive, then pre-Brexit CJEU judgments interpreting that wording, whether arising from a directive or regulation case, remain binding or highly persuasive. This whole Europeanization process has fundamentally shaped UK trademark law.
Okay, summing up the EU impact. Drove the 1994 Act, led to the 2018 regulations, and pre-Brexit CJEU case law remains binding, shaping how we interpret UK trademark law today.
That's the essence of it. You just can't understand modern UK trademark law without understanding that EU context and the CJEU's ongoing legacy.
We have covered a phenomenal amount of ground, from ancient history to modern EU law influences.
We really have. Tracing marks from simple identifiers to complex property rights, through messy case law, key legislation like the 1875 and 1994 Acts.
And clarifying what makes trademarks different, no creativity needed, often not absolute rights, the economic justification, potential perpetuity, but those tensions with competition.
And crucially, unpacking those vital functions. Origin plus quality investment, differentiation, guarantee, advertising with dilution protection, and maybe investment. Repeat. Those functions are really a core takeaway here.
Underlining how EU law shaped the UK system and how pre-Brexit CJEU rulings remain indispensable for understanding it today.
Absolutely. This introduction lays the groundwork. Getting the history, the nature of the right, and especially those functions clear in your head is essential for tackling passing off, registrability, infringement, and revocation in the later chapters.
So definitely worth revisiting bits, if needed, maybe Millington v. Fox on property, or the details of the functions, especially arsenal and the dilution concepts under SS 53103. Really nail those down for your studies and exams.
Definitely. And maybe a final thought to ponder, building on all this. We've seen the functions expand massively from just origin to include quality, advertising, investment. How does this complex, multi-layered reality sit with the simple idea from Millington v. Fox that a trademark is just property? And what does that complexity tell us about the ongoing challenge of balancing the owner's powerful rights with the public interest in competition and clear communication?
That's a great question to chew on. A reminder that this deep dive was for educational purposes, using the excellent material from the University of London.
And brought to you by Sinorbit Academy, Sri Lanka. Once again, truly the very best of luck to all of you with your studies and exams.
Thanks for joining us on this deep dive into trademarks. Good luck with everything.